Welcome to this seminar on the exorbitant jurisdictions of the Commercial Court. It's 21 years since I ceased to be a judge of that court, and I think its jurisdictions have grown considerably more exorbitant since I left it. So I'm going to learn quite a lot this afternoon, as I hope is everybody here. We are going to have 4 speakers, each talking for about a quarter of an hour. Richard Aikens is going to go first, and he's going to talk about exorbitant jurisdiction in respect of foreign arbitrations. When he finishes, there will then be an opportunity to ask him a few questions, because he's got a better party to go on to than the one we're going to be enjoying at the end of the next 3. So may I then invite Richard to kick off.
Thank you very much, Nicholas. I'm going to talk briefly about the powers of the English Commercial Court to support foreign arbitrations. And by foreign arbitrations, I mean arbitrations where the seat of the arbitration is outside England and Wales, or as it's put in the Act, the 1996 Act, where the seat has not been designated or determined. There are broadly 2 types of situation where the English court may be invited to assist. First, there's the case where a party, in breach of an arbitration agreement, has attempted to start court proceedings, or perhaps even arbitration proceedings, in England or elsewhere. If proceedings have been started elsewhere than in England, then we're into what I will call anti-suit injunction territory, and I'm not going to go there. It's very well trodden ground. I'm going to stick to the case where a party tries to start English proceedings in breach of an arbitration agreement. The second situation is where a party to the foreign arbitration seeks the assistance of the English court in the course of the reference. There is, of course, a third part, the possible assistance of the court in enforcing award of a foreign arbitration, but I'm not going to consider that either. Well, what's the background? The background is the restriction set out in Section 1C of the Arbitration Act 1996, stipulating the provisions of Part 1 of the Act, which essentially govern the whole structure of the arbitration, its starting, its middling and its finishing, is founded upon the principle that the parties should be free to agree how their disputes are to be resolved, subject only to such safeguards as are necessary in the public interest, with the consequence that Part 1 of the Act is to be construed accordingly. So, effectively, this means, in my view, that the Act is not to be construed as permitting the court to intervene unless the provisions of the Act say so. Secondly, there are subsections 2 and 3 of the Act, which restrict the exercise by the court of the powers conferred by the provisions of Part 1 of the Act to arbitrations whose seat is in the England and Wales, with limited exceptions. The powers that are not limited just to the seat being in England and Wales are those granted to the court in sections 9 to 11, stay of proceedings, section 43, securing the attendance of witnesses, and section 44, the court powers are exercisable in support of arbitrations. The latter section, as I'm sure you all know, is by its own terms restricted in the circumstances in which those powers can be exercised by the court. Section 2.4 of the Act does give the court the jurisdiction to exercise any power conferred by Part 1 where no seat of the arbitration has been designated or determined, and where, by reason of a connection with England or Wales or Northern Ireland, the court is satisfied that it is appropriate to do so. But if the seat has been identified as being outside England and Wales, then that's not the section that governs, it's 2.3. First then, the situation where a stay is required. Section 9.1 is limited in scope. It gives the English court power to stay proceedings only where the court in which the proceedings has been brought and insofar as those proceedings are in respect of a matter which, under the arbitration agreement, is to be referred to arbitration. So they have to be proceedings in court, and they have to be ones that are the same as would be in the arbitration. The party seeking the stay has the burden of proving that there's a valid arbitration agreement, and it will do so. If it does so, then the court will grant a stay unless Section 9(4) applies. That is to say, the other side demonstrates that the arbitration agreement is null and void, inoperative, or incapable of being performed. In the Court of Appeal decision in Aeroflot and Berezovsky, 2013, 2 Lloyds 242, we had to consider what had to be established before the English court could conclude that the non-English arbitration clause was null and void and inoperative. I gave the main judgment in the court, and I said the correct approach for the English court when a stay was resisted on the grounds of a non-English arbitration agreement being null and void was to take the issue in 2 stages. First, the court had to examine and decide the rules of the applicable law of the arbitration agreement, which was said to lead to the arbitration clause being impugned. Secondly, the court had then to decide the effect of the applicable law by reference to the facts and the English law concepts of null and void or inoperative, but considering those concepts in a kind of international way, bearing in mind they were based on an international convention. The standard of proof was the balance of probabilities, and I pointed out that the court could order an issue to be tried to determine whether the arbitration agreement was null and void or inoperative, but if the evidence and possible findings impinged on the substantive rights and obligations of the parties, then the court was unlikely to do so and would have to leave the matter to the arbitrators. That was a case where the agreement was for Swiss arbitration, so Swiss law concepts had to be considered. In another case, A against B in 2006, Mr. Justice Coleman accepted as correct a concession by counsel that a stay of English proceedings could not be sought under Section 9 if the claim was against an arbitrator whose appointment in a foreign, again Swiss arbitration, was being challenged in the English claim on grounds of invalidity of the agreement or the method of appointment. The court said that it did have jurisdiction to grant a stay of those claims apart from Section 9, doubtless under the inherent jurisdiction of the court. Well, that's a swift look at stay. Secondly, Section 44, the main restriction on the English court's powers there is in Section 2(3) of the Act, which says that the court may refuse to exercise the power contained in Section 44 in relation to a foreign arbitration if, in the opinion of the court, the fact that the seat of the arbitration is outside England and Wales and Northern Ireland makes it inappropriate to do so. It's important to note that Section 2(3) doesn't apply to Section 42, which grants the court powers in relation to peremptory orders of the tribunal, so the court can't help if the tribunal in a foreign arbitration has made a peremptory order. The scope of the jurisdiction of the court to assist a foreign arbitral tribunal is limited to the scope set out in Section 42, subsection 2, and the circumstances in which the court can act are further limited by subsections 3 and 5. Even if all those conditions can be fulfilled, the cases have shown that the wording in the proviso of subsection 3 of Section 2, particularly the use of the word inappropriate, places severe restrictions on the exercises of the court's power. There are a number of cases on this topic, one by Mr. Justice Walker, formerly of these chambers, in Mobile Quero Nigor against Petroleos de Venezuela, one of the counsel sitting on my right here, and Mr. Justice Walker said that the issue of whether it is inappropriate for the court to grant Section 44 relief has to be considered before all the matters raised in Section 44 are themselves considered. The fact that the seat of the arbitration is not in England and Wales is an important factor to weigh. In U&M Mining Zambia against Konkola Copper Mines, Mr. Justice Blair accepted the proposition that the natural court for the grant of interim injunctive relief must be the court of the country of the seat of the arbitration, particularly where the curial law of the arbitration is that of the country of the seat. So Mr. Justice Blair said that in the case of an application that is made under Section 44 in a foreign arbitration, the English court will need a very good reason to exercise its jurisdiction, and that exercise of the jurisdiction will be exceptional. In practice, it will have to be shown that it is only practicable to make the application to the English court, and will have to demonstrate that the English application was not a disguised attempt to outflank the foreign arbitration agreement. Another restriction on the use of Section 44 was pointed out by Mr. Justice Moore-Bick, as he then was, in Commerce and Industry Insurance of Canada against Lloyd's Underwriters in 2002. He said a key factor on whether or not to grant an order under Section 44 was whether the procedural law of the seat of the arbitration was similar to that in England. And he therefore rejected an attempt to use Section 44 to obtain an order for US-style depositions, which he regarded as a fishing expedition. An interesting question arises as to whether, in a case where the seat of the arbitration is outside England and Wales, and the law applicable to the substantive issues between the parties is the law of that foreign seat, but the procedural law of the arbitration is that of England and Wales, will the English court be more inclined to exercise its Section 44 powers? Logically, one might think it would be more appropriate to do so because the English procedural law was the party's express choice, but I haven't come across a specific case. In the Mobile Kero case, Mr. Justice Walker made an elaborate analysis of the basis on which a court would grant a worldwide freezing order in support of a foreign arbitration, where the seat of the ICC arbitration was New York, so that the procedural law of the arbitration was that of New York, but the applicable law of the contract under which the relief was claimed was that of Venezuela. Mr. Justice Walker held that it would only be appropriate to grant a worldwide freezing order in support of a foreign arbitration where the assets were located outside the UK if the respondent to the dispute had a sufficient strong link with England and Wales. That would be a necessary but not a sufficient prerequisite. Further, he said that caution was needed because any order made involved the court assuming jurisdiction over assets that were not within the jurisdiction. In addition, comity had to be considered. Comity, of course, is a bit like public policy. It's an unruly horse that can gallop off with the rider, i.e. the judge, not in control anymore. Mr. Justice Walker did not explain which country's court had to be particularly taken into consideration for the purposes of comity. Was it the seat of the arbitration court and its system, New York, or was it that of Venezuela, where most of the assets were to be found? When the parties to an arbitration are not based in the UK and they're not prepared to accept service of proceedings on solicitors in UK, a party wishing to use Section 44 in support of a foreign arbitration will have the practical difficulty of serving on the defendant party. CPR Part 62.5, 1 in brackets, little b in brackets, states that the court may give permission to serve an arbitration claim form out of the jurisdiction if the claim is for an order under Section 44. The application must be supported by written evidence stating the grounds on which the application is made and showing the country where the person to be served is to be found or probably may be found. If a party wishes to be difficult, this can obviously slow things up considerably, as it did in the case with which Mr. Justice Walker was concerned. The last thing I want to touch on very briefly is the court's power to grant interim injunction relief in support of a foreign arbitration under Section 37 of what is now called the Senior Courts Act 1981. I have a sort of vision of very old-looking courts and courtrooms, which is perhaps quite appropriate for the Royal Courts of Justice. It used, of course, to be the Supreme Court Act before it was changed under the Revolutionary Acts of 2005. There's a continuing debate, as I'm sure you all know, about the extent to which Section 37 fits in with Section 44, subsection 2e of the Act, which grants the court the power to give injunctions in arbitral proceedings. The consensus is that there remains a residual power under Section 37. Parties have tried to invoke Section 37 to obtain anti-arbitration injunctions in at least one case where there was a foreign arbitration, although the injunction was sought in respect of an English arbitration. That was a case in which I was the judge, Electrim SA against Vivendi Universal in 2007, where Electrim sought an injunction against Vivendi from pursuing an LCIA arbitration in London, where there was also an ICC arbitration between the same parties going on in Geneva. I held that an injunction would not be granted unless the claimant satisfied the court that the arbitration proceedings sought to be enjoined constituted an infringement of the legal or equitable rights of the claimant, or that the arbitration proceedings in question were vexatious, oppressive, or unconscionable. The first ground would obviously usually apply where there had been a breach of contract in bringing the arbitration proceedings sought to be enjoined. The second applied in the absence of some such contractual agreement, and I held that Electrim could not prove either in that case. I also commented on the interrelationship between the court's power to grant an injunction in relation to arbitration proceedings under Section 37 and the scheme of the 1996 Act. I concluded that the aim of Part 1 of the Act was to restrict the intervention of the court during the period before an award to a minimum. Therefore, Section 37 should not be used to try and short-circuit the arbitral procedure, which had the power itself to decide issues of jurisdiction or competence if Section 33 or some other equivalent applied. In that case, the arbitrators appointed under the LCIA arbitration could decide their jurisdiction under the LCIA rules and also pursuant to Section 33. The court has no power to overrule that decision before an award is made. Thus, I held it would be wrong to try and invoke Section 37 to get round the restrictions placed by the structure of Part 1 of the Act on the role of the court. To sum up, therefore, the court will stay proceedings that are contrary to foreign arbitrations. It has the power to grant relief in support of foreign arbitrations, but will use them only very sparingly. The court has the power to grant interim injunctions pursuant to Section 37 of the 1981 Act, but it will not use that power either to avoid the restrictions placed on the court's powers by Sections 2, 3, and 44.3 and 5 of the 1996 Act, nor will it use Section 37 as a means of sidestepping the restrictions on the court's power to intervene in jurisdictional issues prior to the issue of award. Therefore, you might conclude that the jurisdiction of the English court in support of foreign arbitrations is not too exorbitant after all.
Thank you, Richard. Any questions?
No.
Not at all.
Slam dunk.
Well, I think I'm not quite sure what we conclude from that, other than that you're not going to be late for your next engagement.
Either I've been too quick, or it's impenetrable, or
It's
I've
so
dealt
clear.
with all the things that might have been dealt with. That's for Alec. I'm quite sure there's no question. I'm sorry I can't be here to answer any questions that might be raised privately, but you can always send me an email. Okay, thank you very much. Sorry I was.
Okay, right. Michael, would you like to introduce your topic, say what you're going to talk about?
Yes. I'm going to talk about relief against third parties, and particularly a freezing order relief against third parties outside the jurisdiction. As that title suggests, we'll predominantly be looking at the interesting issue of the court's jurisdiction to grant relief against non-parties, or that is entities against which the claimant has no cause of action, so-called NCADs, or non-cause of action defendants. In 1989, the reduced Shakespeare Company managed to perform all of Shakespeare's 37 plays in 97 minutes. what I've got to do is get 40 years of freezing order into about 20 minutes. So it's a similar sort of task. But here we go. Before we start looking at relief against third parties, it's worth briefly reminding ourselves as to how the Matravers jurisdiction has developed since 1975 in outline. In fact, the first case to grant a freezing order wasn't the Matravers case at all. It was Nippon Yusen Keisha against Karageorgis. So rightly we should be talking about Karageorgis injunctions, but I suspect those two brothers are rather glad that they ducked that rather dubious immortality. Anyway, whatever the original freezing order should or should not have been called, it was a pretty simple beast in that it was an order against a defendant outside the jurisdiction against whom there was a cause of action, and it froze assets within the jurisdiction. So it's what we would now regard as a pretty vanilla freezing order. Importantly, there was obviously an extant cause of action before the English courts. The first attempt to push that jurisdiction further, of course, came in the Susquehanna, where you had substantive proceedings in Genoa, and there was an attempt to obtain freezing order relief in England, and the House of Lords said no, there is no power to issue any freezing order relief unless there are substantive proceedings before the English court, for the simple reason that it's an interim remedy, it's an interlocutory relief, and therefore there had to be some substantive cause of action to which it could be interim. But importantly, in the Susquehanna, Lord Diplock noted that if there was some substantive right enforceable before the English court, or one that the court might be required to adjudicate upon, then provided the defendant was capable of being served, then the injunction could be issued against him even if he wasn't in the jurisdiction. So what that comment draws attention to are the twin requirements of a substantive cause of action subject to the English court's jurisdiction, but also personal and or territorial jurisdiction over the particular defendant. And those are two considerations which, as we'll see shortly, have recently come sharply into focus in the context of freezing orders against foreign non-parties. Now, the requirements in the Susquehanna were somewhat refined a couple of years later in the Channel Tunnel case. As you know, that pushed the boundary a bit further. Where it was a case where there were arbitration proceedings in France and a freezing order was sought in England. On the face of it, the Susquehanna applied, but Lord Brown-Wilkinson said no. Because it was possible to bring proceedings in England, it was possible for the substantive proceedings to be brought in England, even though they would almost inevitably be stayed in favour of the foreign arbitration, that was enough. But again, the focus was on whether there was a potential matter over which the English court could issue a final determination. Now, of course, nowadays things are much simpler, because the actual effect of the Susquehanna, pardon me, the effect of the Susquehanna has been reversed by Section 25 of the 1982 Act, and as extended by various statutory instruments, so the court now has power to issue freezing order relief, worldwide freezing order relief, in support of proceedings elsewhere. So, just as by way of recap, by the time we get to the Channel Tunnel case in 1993, the power of the court to order freezing order relief against a defendant was dependent upon a substantive cause of action before the English court, or a cause of action which existed, which was capable of being determined by the English court, even though it might not ultimately be determined by that court. There was also the statutory power under Section 25 of the 1982 Act, and of course 3 years after the Channel Tunnel case, the 1996 Arbitration Act came along, Section 44, and you got as Richard alluded to, the potential for the court to issue freezing order relief in support of foreign arbitrations. Now, the fact that the court's got the power to grant the relief is, of course, only the first stage of the analysis, because the claimant also has to establish territorial jurisdiction over the defendant, that the defendant can properly be served and brought before the English court. Now, given that introductory recap of where we got to on the substantive jurisdiction, the question that next arises is over what assets of the defendant could the court grant freezing order relief. Initially, obviously, the Matravers injunction was, in the Matravers case itself, over assets within the jurisdiction, but very soon that was expanded in 1990 in Babanaft, when the court accepted that there was jurisdiction to freeze assets of the defendant outside the jurisdiction, and that power is now expressly contained in CPR 25.11F. But Babanaft also importantly laid down some important restrictions to the scope of freezing orders affecting assets outside the jurisdiction. In particular, although the worldwide freezing order binds the defendant not to dispose of his assets outside the jurisdiction, it doesn't, of course, first stage, it also, of course, binds third parties within the jurisdiction who are served with the order because they're subject to the court's contempt jurisdiction. What it doesn't do is it doesn't have any impact on third parties outside the jurisdiction, even if they've been served with the order. And to make that clear, the standard form worldwide freezing order contains the Babanaft proviso, which has been variously revised, but essentially says it makes it clear to third parties that it has no effect on them. And the reasoning behind the proviso is obviously clear. It's inappropriate for the court's order against the defendant to impact on a third party outside the jurisdiction and over whom the court has no jurisdiction. But importantly, being served with a worldwide freezing order is not the only way that a third party can become implicated in an action before the English court. And that's because it's well established that the court's got power to freeze the assets, to issue an order not simply against the defendant, but to freeze the assets of the third party themselves. And that power enables the court to freeze the assets of a third party against whom the claimant doesn't actually have a cause of action, so-called non-cause of action defendants, NCADs. And that power was obviously first recognised in Chabra. But importantly, the contention in Chabra was that Mr. Chabra, the judgment debtor, owned shares in a company, and a company in Coventry, but it was said that the company's assets were beneficially the assets of Mr. Chabra. And Miss Justice Mummery accepted that submission, accepted that there was a good arguable case, so that's your threshold, good arguable case that the assets of a third party were in reality the actual beneficial assets of the cause of action defendant, and that was sufficient in Chabra to enable the court to freeze the third party's assets. Of course, Mr. Justice Mummery ran straight into the Susquina when he started to analyse the position, because on the face of it there was no substantive cause of action against the Coventry-based company, which was justiciable before the English court. That problem was circumvented by the simple, by Mr. Justice Mummery's analysis, to the effect that in Susquina you only had one defendant, one cause of action, which was being heard in Italy, whereas in TSB and Chabra there were two defendants, and there was a substantive cause of action before the English court against Mr. Chabra, and that was sufficient to enable the court to issue the relief against a third party, which was ancillary to and dependent upon the cause of action against Mr. Chabra. Now, TSB and Chabra was an important extension, but it doesn't represent the outer limits of the court's powers over the assets of a non-cause of action defendant. The question whether the court could go further was raised by Mr. Justice Aikens in C against L. C against L was important because it addressed what the judge called the crucial question, which he said was whether the court can go one stage further than Chabra. Does it have power to grant a freezing order against the assets of C, a third party, when A has a substantive right against B, but secondly, the assets of C are not even arguably beneficially owned by B? So he's going beyond Chabra, and the answer to that question was yes. In some circumstances, it is possible to freeze the assets of a third party, even though they are not even arguably beneficially owned by the cause of action defendant. There have been various explanations as to the scope and function of that jurisdiction. Mr. Justice Gloucester explained it in Parbook, and Sir John Chadwick, sitting in the Cayman, explained it in Algo Saibi. Essentially, the reasoning is, provided there is a demonstrable mechanism by which the claimant can execute at the end of the day against the assets of the third party, whether by third party debt order, charging order, appointing a receiver over the cause of action defendant's assets, provided there's some way that the claimant can get at the assets of the third party and use them to satisfy any eventual judgment debt, then there is potential to order freezing order relief against that third party, despite the absence of any claim to beneficial ownership. Now, that's the outer limit of the substantive jurisdiction, but that's very far from the end of the matter, because the fact that the court has power to order particular relief doesn't mean that it can necessarily be invoked against a particular defendant, and that depends on territorial jurisdiction, and that's proven a very difficult area for potential claimants. That's because it's self-evident that if one moves into the Chabra jurisdiction, whether original or extended, by definition you're dealing with an application against an entity against whom there's no cause of action. So it makes it very difficult to establish a basis on which one could serve out. The obvious basis is 3.13 of the practice direction, which is the necessary and proper party provision. But there are formidable hurdles in proceeding under that gateway. They've been considered in a number of cases, Belletti, CNL, Parbook, and most recently City, Cruise and Unitech. Needless to say, the holy grail in preparing a talk like this would have been to find a decision of Mr. Justice, better still Lord Justice Aikens, which had been reversed by Lord Phillips. Sadly, despite extensive research, I've not been able to find one. But we do have Mr. Justice Aikens' decision in CNL. That's as close as we could get. Now, the first difficulty to the necessary and proper party gateway is that it's pretty clearly been established that in order to rely on the necessary and proper party gateway, you must have a necessary and proper party to a claim or an issue which it is reasonable for the English court to try. In other words, you have to have your anchor defendant in the first place, and there's got to be a substantive cause of action against that anchor defendant. That's obviously got echoes of the Siskina, although the reasons for the requirement are very different. And as Mrs. Justice Gloucester pointed out in Parbook, this isn't a matter of discretion. Because it goes to the existence of the gateway. If the gateway conditions aren't satisfied, then there is no power to permit service out under 3.13. Now, the consequences of that can be stark. It means, for example, if you're relying on Section 25 and you're trying to establish freezing order relief in support of foreign proceedings, you can't get through the gateway because there's no substantive cause of action before the English court to which the non-cause of action defendant could be a necessary and proper party. The second point is that you have to exercise great care as to the timing of when you make your application against your non-cause of action defendant, because whether there is still an issue which it is reasonable for the court to try may depend on the stage of the process at which you make the application against the non-cause of action defendant. Now, even if one can avoid that problem, and even if one could say, okay, well, it's not necessary under Section 25 to establish a substantive cause of action, or even if you could say, well, we've got proceedings, substantive proceedings elsewhere, but there are still proceedings before the English court, perhaps for the appointment of a receiver, perhaps for the declaration of individual invalidity of a trust, the declaration that it's a sham trust. You've got some issue before the English court that it's reasonable for the court to try. You still have the formidable hurdle that under Section 25, the second part of the test is that the court can only grant relief in support of foreign proceedings where it's not inexpedient to do so. And the difficulty is, and this was discussed at some length by Mr. Justice Mayles in City Cruise and Unitec, the difficulty is that where you've got no assets in England, you've got no cause of action against the non-cause of action defendant in England, and the defendant has no presence in the jurisdiction, then even if theoretically you could go under Section 25, you're going to find that the court says, in accordance with the decision in Motorola, that it's inexpedient to do so. That's precisely the conclusion that Mr. Justice Flo reached in the Belletti case, but he also went further and said in circumstances where you've got no assets, no cause of action and no defendant or party within the jurisdiction, then the court's got no way of enforcing its order, and again that makes it inexpedient to make the order. Moreover, even if you can get over that hurdle, of course the issuing of freezing order relief is discretionary, and the fact that the defendant and the assets, etc., are out of the jurisdiction will go to discretion. And again, in this regard, Mr. Justice Mayles' decision in City Cruise and Unitec is interesting. In that case, he had several potential non-cause of action defendants, some in Cyprus, some in the Isle of Man, and some in India. He said that had he concluded he had the power, he would have exercised his discretion to permit service out. However, he then went on to point out that there was a problem, that because the Cypriot companies were resident or domiciled within a member state, then Article 31 of the Brussels regulations applied. The consequence of that was that the decision of the ECJ in Van Uden requires that for interim relief to be, the jurisdiction for interim relief depends upon a real connecting factor with the jurisdiction, which he said in the case of freezing order relief meant a real connection between the jurisdiction and the assets. There was no such real connection. Therefore, the English court didn't have jurisdiction as a result of Article 31 against the Cypriot companies. And as a double whammy, he then said, because he had concluded that as a result of the regulations he had no power to freeze the assets of the non-cause of action defendant in Cyprus, that weighed in the balance when he exercised his discretion in relation to the Indian and Isle of Man companies. And he said, because he couldn't bring the Cypriot companies in and have it all determined in one fell swoop, he would, had he got to that point, he wouldn't have exercised his discretion to permit service on the Indian or Isle of Man companies. So,
Michael, you've run out of time.
Yes, can I just do my takeaways?
Takeaways, okay.
Takeaways, well, Well, let me give you, in fact, the final word. First, the power to grant relief against third parties is wide. Secondly, it's more easily available against those domiciled and subject to the English court's jurisdiction. It is possible to obtain relief against non-parties outside the jurisdiction, as the decision in CNL demonstrates. And finally, the one thing I would say is that we have this wide substantive jurisdiction. We have the restrictions on that which are created by the difficulty in serving. Those are created by the CPR, and the consequence of that is that if you are, for example, looking at the BVI or Cayman or another jurisdiction, of course, the rules for service out are markedly different. So even though these Caribbean and other jurisdictions may have the same substantive jurisdiction, it doesn't follow that their territorial jurisdiction is the same or necessarily so limited. So take care.
Thank you very much. I've always thought that Denning's greatest contribution to English law was probably the invention of the Matravers injunction, because up to then there was no power to get security over property until you got judgment, by which time it was usually too late. And I remember the start of this story. It was an Admiralty barrister called Geoffrey Bryce who sought to persuade John Donaldson in the Commercial Court to grant an injunction. And Donaldson said, no, there's absolutely no jurisdiction. If you don't believe me, go to the Court of Appeal. So he went off to Lord Denning, and Lord Denning invented this jurisdiction. The second case was the Matravers, but that was not contested in the Court of Appeal. And of course, the first case was ex parte in the Court of Appeal. I was in the third case, which did go to the Court of Appeal, where Michael Mustill had the uphill struggle of trying to persuade Denning that he had no jurisdiction to grant the injunction. So I won on the law, but I lost on the facts, because I was trying to Matravers a cement mill that was about to be exported to Indonesia, and Denning didn't think that was a very good idea. Anyway, there we are. But he did make an immense difference, practical difference, to English law and certainly commercial law. Right. Might be me next.
I want to discuss briefly the rules relating to alternative service under CPR Rule 615, and in particular the application of those rules in cases where a defendant is resident outside the jurisdiction. As a reminder, CPR 615 states that where it appears to the court that there is good reason to authorise service by a method or at a place not otherwise permitted by this part, the court may make an order permitting service by an alternative method or at an alternative place. Paragraph 2 enables the court retrospectively to declare that steps already taken to bring the claim to the attention of a defendant constituted good service. CPR 615 is expressly stated only to apply to the service of a claim form, but by virtue of CPR 627, the same rules apply to the service of any other document by any party. I think the first question is whether or not CPR 615 applies at all in a case where a defendant is resident outside the jurisdiction. It's not immediately obvious that CPR 615 applies in such cases. It sits within Section 2 of Part 6 of the Civil Procedure Rules, which deals only with the service of a claim form in England or Wales or the EEA. It's Section 4 of Part 6, which deals with the service out of the jurisdiction, and that section contains no provision equivalent to CPR 615. It is, however, now well established that the court has the power to authorise alternative service in cases where a defendant is resident outside the jurisdiction. In Abila and Badarani, Lord Clark suggested that the rules in CPR 615 are to be implied into CPR 637, paragraph 5b, or alternatively he said that such a power is to be implied generally into the rules governing service abroad. CPR 637, paragraph 5 is the rule that states that where the court gives permission to serve a claim form out of the jurisdiction, it may give directions about the method of service. So it's clear, therefore, that one way or another, the rules in CPR 615 apply in all cases. Abila and Badarani is still the leading case on CPR 615, although there have been 5 subsequent Court of Appeal judgments concerning that provision. In Abila, Sir Edward Evans Loam made an order retrospectively declaring that a defendant resident in Lebanon had been validly served as a result of documents being sent to his Lebanese lawyer. The Court of Appeal held that he had been wrong to make that order. Lord Justice Longmore thought that the use of CPR 615 in a case where the defendant is resident outside the jurisdiction should be regarded as exceptional. He said that the exercise of the power under CPR 615 is liable to make what is already an exorbitant power still more exorbitant. He suggested that as a result, the power must be exercised cautiously and should be regarded as exceptional. And the Supreme Court, when it considered this, unanimously disagreed. Lord Sumption made a number of comments which indicated that he took an expansive view of the English court's power to exercise jurisdiction over foreign defendants. Those comments have relevance, of course, not only to CPR 615, but also generally to the rules governing the granting of permission to serve out. Lord Sumption suggested that it's not plausible to view the service of process abroad as an assertion of sovereignty, and he said that it should no longer be necessary to resort to the kind of muscular presumptions against service out which are implicit in adjectives like exorbitant. Lord Clark agreed with those sentiments and emphasised that exceptional circumstances are not needed for an alternative service order to be made, even in a case where a defendant is resident outside the jurisdiction. What is required is simply a good reason to make the order. However, a stricter test seems to apply in cases where the 1965 Hague Service Convention or a bilateral service treaty applies. In such cases, it seems that exceptional circumstances are required for an alternative service order. Although such a distinction is difficult to reconcile with the wording of CPR 615, it seems to me that a stricter test for cases in which a service treaty applies is justified because the order risks undermining the provisions of the treaty. In Abila, Lord Clark specifically stated that he was not considering such cases. Both the Court of Appeal judgment in Cecil and Bayet and the judgment of Mr. Justice Cook in Deutsche Bank and Sebastian Holdings certainly seem to me to suggest that exceptional circumstances are required if the Hague Service Convention applies. And I think that's also suggested by the recent Court of Appeal judgment in Actual Pharmaceutica and Simone. That was a case in which the Hague Service Convention applied, but an order was nevertheless made retrospectively authorising alternative service of a committal application on a defendant resident in Switzerland via his lawyers in London. The committal application arose out of the fact that the defendant had failed to comply with an interim injunction. The court indicated that there were exceptional circumstances justifying the alternative service order because compliance with the injunction was urgent, and the delay involved in serving via the Hague Convention could have rendered the injunction useless. It must be remembered that CPR 640 paragraph 4 states that nothing in court order authorises a party serving court documents abroad to do anything which is contrary to local law. But it's important to recognise that this does not require the method of alternative service under CPR 615 to be valid under local law. CPR 640 lists the methods permitted to serve in order to serve a defendant outside the jurisdiction, and those methods include not only service via diplomatic channels, but also service via any method permitted by local law. So if such a method can be used, CPR 615 is simply not required. It follows that where CPR 615 applies, the method of alternative service necessarily will not constitute good service under local law. It's also important to remember that although CPR 615 applies in cases where a defendant is resident outside the jurisdiction, that does not mean that the rules on the granting of permission to serve out can be bypassed. Permission to serve out will still be required if the defendant is resident outside the EEA. So what then are the requirements under CPR 615? Well, the answer to that in a sense is very simple. In Abila, Lord Clark stressed that the only requirement to be met before a court can make an order authorising alternative service is that, having regard to all the circumstances, there must be a good reason to do so. And he said that it's not appropriate to add any gloss to that test. As I've said, exceptional circumstances are not required unless it seems a service treaty applies. And the fact that an application under CPR 615 may have not been made until after the expiry of the claim form does not prevent the court retrospectively authorising alternative service. And that can be seen from the Court of Appeal decision in Khaki and the National Private Air Transport Company. The claimant in that case had brought a claim in England against a Saudi company for breach of contract. Permission to serve the company in Saudi Arabia was granted, and steps were then taken to effect service via the consular authorities, but that proved to be ineffective. The judge granted an order under CPR 615-2, retrospectively declaring that the sending of the claim form to the defendant's in-house lawyer constituted good service. The application was made some 9 months after the service of the claim form expired. The period of validity of the claim form. Unlike in a BILA, where the application was made well within that period, the Court of Appeal upheld the alternative service order made by the judge. Lord Justice Aikens rejected the suggestion that a stricter test must apply if the application is made after the claim form has already expired. He emphasised that the language of CPR 615 draws no distinction between cases in which the application is made after the expiry of the claim form and cases in which the application is made before that deadline. The authorities demonstrate that when dealing with applications under CPR 615, the Court will consider all the circumstances of the case in order to assess whether or not a good reason for alternative service exists. I'll highlight some of the relevant factors, although this is obviously not intended to be an exhaustive list. The first and most important factor is whether the defendant has been or will be made aware of the nature of the claim against him. In a BILA, Lord Clerk stated that the most important purpose of service is to ensure that the contents of the document served is communicated to the defendant. I think in every case in which an order authorising alternative service has been made, the defendant either already had been made aware of the nature of the claim within the period of validity of the claim form, or he was highly likely to be made aware of the claim using the method authorised by the court. However, that alone obviously is not sufficient, because otherwise there'd be no reason, no need to comply with the formal rules of service. So the second factor is the conduct of the claimant. The reason why the claim has not been and cannot be served using the usual methods is highly relevant. In Khaki, Lord Justice Aikens said that there will inevitably be a focus on the reason why the claim form cannot or could not be served within the period of its validity. Therefore, the conduct of the claimant and his advisers in this regard and the timing of the application are likely to be relevant factors for the judge to consider. In any application under CPR 615, therefore, the claimant will need to identify what steps have in fact been taken to try to serve the defendant using the normal methods. And this, I think, is demonstrated by the recent case of G7 and Personal Management Solutions Limited, which was a copyright infringement claim. A claim form in that case was served on the defendant's solicitors, but that was not good service because the defendant's solicitors had not indicated that they were instructed to accept service of proceedings. After the expiry of the claim form, the claimant sought an order under CPR 615-2, retrospectively declaring service of the claim form on the defendant's solicitors to be good service. Mr. Justice Arnold refused to make the order on the basis that the claimant had taken no steps to effect service until the last working day before the claim form expired, and the claimant had failed even to attempt to serve the defendant itself, as opposed to its solicitors. And there was no reason why they could not have done so before the claim form expired. That case, I think, shows that a delay in seeking to effect service will be an important consideration, although it's obviously not decisive. In BILA, for example, an alternative service order was made despite the fact that the claimant had delayed for 3.5 months before trying to effect service of the claim form. Unlike a retrospective application to extend time for service of claim form under CPR 7.6, it's not necessary under CPR 615 to show that the claimant has taken all reasonable steps to effect service. However, what is required is to show that a serious effort has been made to serve the defendant via the normal methods. When assessing the steps that have in fact been taken to effect service, the fact that the claimant may be a litigant in person is a relevant consideration. But the Court of Appeal in Barton and Wright Hassel recently stated that the mere fact that the claimant is a litigant in person cannot itself amount to a good reason to validate alternative service. The third factor is the conduct of the defendant. If the defendant's conduct can be characterised as uncooperative or playing technical games in order to avoid service, that is likely to be an important factor suggesting that alternative service should be authorised. Lord Clark in Abela obviously considered the uncooperative and obstructive attitude of the defendant in that case to be highly relevant. He highlighted the fact that the defendant's lawyers in that case had denied that Mr. Badarani lived at the relevant address in Beirut, and they'd refused to say where he did live. It was emphasised that the defendant had no obligation to disclose his address to the claimant, but his refusal to cooperate was a relevant factor to be considered. The relevance of the defendant's conduct can also be seen in another recent Court of Appeal case, this time Power and Malloy Whittle Robinson solicitors. The claimant in that case issued a professional negligence claim against the defendant firm and informed the court that it intended to serve the claim form itself, but the court mistakenly sent the claim form directly to the defendant. That was not good service because, amongst other reasons, the defendant had informed the claimant that he wanted the documents served on its solicitors. The defendant's solicitors queried whether formal service had taken place, but they did not suggest that they would be arguing in due course that the claim had not been properly served. Indeed, they proceeded on the assumption that service had been effected. After the limitation period had then expired, the defendant argued that the claimant had not been properly served and resisted an application under CPR 615-2. The court viewed the conduct of the defendant's solicitors in that case as uncooperative, given that they knew full well that the claim had not been served properly. And indeed, they had lulled the claimant into a false sense of security about whether the claim had been properly served. And that was a factor which encouraged the Court of Appeal to rule that the judge should have made an order authorising alternative service in that case. The courts have identified two factors which are irrelevant under CPR 615, and they are, firstly, events that take place prior to the issue of the claim form, and secondly, the fact that the defendant may not have been aware of the court's power under CPR 615-2 when he received the court documents. The final point I want to address is whether or not default judgment can be entered against the defendant at the same time as making an order retrospectively authorising alternative service. In Khaki, as I've already mentioned, the Court of Appeal upheld an order retrospectively authorising alternative service on a defendant in Saudi Arabia. Lord Justice Aikens confirmed that the result of that order was that a summary judgment order that had been made in favour of the claimant could not be set aside as of right. He said that a validation order under Part 615-2 must have a retroactive effect not just for the purposes of identifying the date on which the claim form was deemed served, but for all subsequent events. And that must be right, because an order under CPR 615-2 operates retrospectively, so any subsequent steps taken in the proceedings must be viewed as having been taken after proper service of the claim. Lord Justice Aikens' comments in Khaki appear to have caused some confusion. They were referred to by Lord Justice Longmore in a case called Dubai Financial Group, a national private air transport services company, which coincidentally involved the same defendant as Khaki. In the Dubai case, default judgment was entered against the defendant at the same time as an order retrospectively authorising alternative service. It seems to me to be clear that that cannot be permissible, because there is no obligation on the defendant to acknowledge service or file a defence unless and until he's been properly served. If default judgment can be entered again at the same time as a retrospective alternative service order, that fundamentally removes any ability of the defendant to defend the claim if he's not already chosen to do so, which is unfair and unjust. It's also clear from CPR 615, paragraph 4c, that any order authorising alternative service must allow for a period in which the defendant is required to acknowledge service or file a defence, which again seems to reinforce this. The majority of the Court of Appeal recognised this and set aside the default judgment order made by the judge in that case, with Lord Justice Longmore dissenting on this particular point. As Lord Justice McComb said, if a defendant has never become under a valid obligation to acknowledge service, either under the rules or by order of the court, I do not see how it can be that a judgment can be entered against him in default of such acknowledgement. He's simply not in default at all. So, in summary, the courts adopt a flexible and pragmatic approach to applications under CPR 615. And the courts will consider all the circumstances of the case, and in particular, whether the defendant has been or will be made aware of the nature of the claim against him. The fact that the rules under CPR 615 have been held to apply to cases in which the defendant is resident outside the jurisdiction, I think provides a valuable safeguard for claimants in cases where service via the normal methods proves to be impractical.
Thank you very much. Last word, Alec.
My topic is obtaining disclosure and information from non-parties resident abroad. You may be thinking as you go along, trying to spot the odd one out. I can give the game away. I'm not going to talk about a decision of Mr. Justice Aikens. Now, this problem occurs on a regular basis, but I found it in cases involving the oligarch disputes more than others, which have got nothing to do with this jurisdiction at all, except perhaps that one of the defendants was domiciled in the UK and was able to be served with process. But you come across a situation in which you've got a prospective witness and he has documents which are relevant and potentially decisive of an issue, but which are not in the control of either party. The witness may be approached informally and refused to produce them voluntarily, and the witness is resident abroad. So what can you do to get those documents? The starting point is that English compulsory process is an exercise of sovereign power, and the court cannot issue a subpoena for service in a foreign country directly compelling a witness either to attend trial or to produce documents for use at trial. Accordingly, there is no provision for service of a witness summons outside the UK. Now, when you start looking at this, you'll see that there are procedures in place. There's the procedure of a letter of request, particularly useful when the witness is actually resident and located abroad. But the success of that depends on the English court being willing to issue a request for assistance and on the foreign court being willing to respond to the request. There are treaties, there's the Hague Convention, there are bilateral conventions, and until Brexit there's the taking of evidence regulation. The system combines court procedures and diplomacy in a way which preserves the interests of both jurisdictions concerned, because the evidence is taken under the process of the foreign jurisdiction if the foreign court responds. Alternatively, you may find, very rarely, that a country has its own special procedures for obtaining disclosure against people, regardless of the fact there are no proceedings in that jurisdiction. The commonly cited example is that of the USA. There are proceedings under 28 USC section 1782 to obtain disclosure in support of foreign proceedings. And a court in England won't stop you doing that unless it's got good reason for doing so. That's the South Carolina case. But then you might come back to your oligarch case and you may find that a letter of request is not going to be particularly effective, and the country concerned doesn't have any procedures for getting information or documentation from a witness. So when we sit down and talk about what we're going to do, we sometimes think about the prospect of this intended witness coming to Knightsbridge for his annual shopping trip and being surprised in one of the shops with a personal service of a subpoena. Either, probably not to attend the trial, but perhaps because he's going to come anyway, but to bring documents with him. In that case, of course, he's not resident, but he's present in the jurisdiction, which means that you can serve the subpoena on him. So that seems all right. But then we come across the case of McKinnon and Donaldson, Lufkin and Jeanette Securities. It's an old decision, it's 30 years old now, and it's a decision of Mr. Justice Hoffman as he then was. The facts in that case were the claimant wanted to get hold of documents held by a bank in New York, didn't apply for a letter of request or go down the section 1782 route, but instead applied for an ex parte order for disclosure of documents under the Bankers Book Evidence Act and by way of a subpoena against the officer of the bank. It was an order requiring production of documents held in the head office in New York, and they related to a transaction conducted abroad. But they were able to serve the process on the branch which was located in England. The respondent nevertheless applied to set aside the order on the grounds that it exceeded the international jurisdiction of the court and infringed the sovereignty of the USA. The applicant quite simply said, well, the bank is present and there are rules which allow service on it in the jurisdiction, so what is the problem? Mr. Justice Hoffman said, I think this argument confuses personal jurisdiction, i.e. who can be brought before the court, with subject matter jurisdiction, i.e. to what extent the court can claim to regulate the conduct of those persons, It does not follow from the fact that a person is within the jurisdiction and liable to be served with process that there is no territorial limit to the matters which the court may properly apply its own rules or the things which it can order such a person to do. The content of the subpoena and order is to require the production by a non-party of documents outside the jurisdiction concerning business which it has transacted outside the jurisdiction. And if you just pause there, that might very well be the case in an oligarch trial which concerns a dispute which has nothing to do with England. The judge says, in principle and on authority, it seems to me that the court should not impose such a requirement upon a foreigner, and in particular on a foreign bank. The principle is that a state should refrain from demanding obedience to its sovereign authority by foreigners in respect of their conduct outside the jurisdiction. And this case, although it's 30 years old, hasn't received much discussion, but appears in all the books, Hollander, Matthews and Manick, and the principle is stated in Phipson on evidence in these terms. A witness summons may be summoned on a person during a temporary visit to the UK, and it is open to the court to set aside the summons if it considers that it would be unduly burdensome to require the individual to return to the UK for the trial. Well, in our case, where I'm trying to get the documents from a witness who's coming to trial, that shouldn't be a problem. But it goes on to say, other than in exceptional circumstances, the court should not require a non-resident who is not a party to the proceedings but who happens to have been served during a temporary visit to the United Kingdom to produce documents held outside the jurisdiction, and cites the McKinnon case. And in case it was thought that this was just out of date, that case has been cited and acknowledged by Mr. Justice Warren in, albeit a tax case, in Clavis Liberty Fund in 2015. But does it really matter that the documents are held abroad and relate to a transaction abroad? If the defendant had been resident in the UK, there's no reason why the court wouldn't have made the order. Mr. Justice Hoffman in McKinnon said, at least on an application to set aside the subpoena, a court applying the principle will at least consider whether there are circumstances which are, in an exceptional case, justify the making of this exorbitant order. Well, where alternative legitimate procedures are available, he had some basis for saying, well, unless there's some kind of urgent necessity and some reason why you haven't done anything to date, you can't get the order. But if no procedures, such as letters of request or direct applications, are available, then surely the fact that the witness is intending to give evidence without producing documents against which his evidence could be tested should justify the order. It ought to be an exercise of discretion, and this reference to infringing sovereignty seems now to be outdated. Compare, if you will, the jurisdiction assumed by the court to issue Norwich Pharmacal orders against non-parties. They're not mere witnesses, of course, because they've been involved in wrongdoing, but they're abroad and they're not directly liable to anyone. Mr. Justice Hoffman in McKinnon compared the jurisdiction to require disclosure of information and documents under Norwich Pharmacal with that under a subpoena, and said it too, Norwich Pharmacal, is an exercise of sovereign authority to assist in the administration of justice. Now, recently, courts have shown a willingness to allow service of Norwich Pharmacal proceedings out of the jurisdiction, despite there being no obvious basis for them to do so. And there's been no expression of concern in those cases about sovereignty. The two cases involve claims, substantive claims, that the claimant wants to make for defamation, trying to find out the identity of the wrongdoer, the person who's published defamatory statements on the internet, and the orders have been, the process has been served on defendants who are web service providers resident abroad. In Lockton Companies versus Persons Unknown and Google, the judge was persuaded to permit service out on the basis that Google was a necessary and proper party to a claim, albeit that hadn't been made, against persons unknown, on the basis that, well, if Google were to identify the person concerned, then a claim form was likely to be served. That doesn't seem to me to be within the spirit of the rule about permitting service against a necessary and proper party. And when you think about it, Norwich Pharmacal is there when you can't issue proceedings without getting the information sought. If you can, then you don't need a Norwich Pharmacal order. The other case is Bacon and Automatic Incorporated, where Norwich Pharmacal proceedings were permitted to be served out on the grounds that the claim against the Norwich Pharmacal defendant was for an injunction requiring the defendant to do something within the jurisdiction, i.e. provide the information to the claimant's solicitors. But if that were right, if you just pause to think about it, you can always serve proceedings for Norwich Pharmacal relief against anyone, anywhere, because the relief is always to provide information within the jurisdiction. Now these of course are two short judgments, and they reflect an order made on an ex parte application. The orders weren't challenged, so arguably if they had been, they would have been set aside. So you may be a bit cautious about relying on them. But on the one hand, it seems to me that those two cases are examples of an exorbitant jurisdiction being assumed. And on the other hand, if we go back to the case of trying to get documents from a witness who's about to attend trial or going to in the near future, we shouldn't be held back by statements like the ones in McKinnon about orders requiring production of documents from non-parties resident abroad being exorbitant, and they ought to be granted in this day and age.
Well, thank you very much. We've got 5 minutes before 7:30. Has anyone got a burning question that they want to ask, as it were, in public? If not, they can save up the question to buttonhole the...
Well, we're having a nice well-earned drink.
Well, we're having a well-earned drink. Anyone want to ask a question before we adjourn? Very good audience. We will just express our approval for our speakers and then move on to have a drink.